Your case is on for trial, and now it's time for cross-examination. And you're sitting in the back of the courtroom wondering whether or not the witness that your attorney is going to cross-examine is going to turn into a quivering blob of JELLO. You want to know what this is all about? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now let's say this is a medical malpractice case. You have this expectation, you have this anticipation that when your attorney gets up to cross-examine the opposing medical expert, the doctor's medical expert who is coming in to oppose everything about your case, you go ahead and believe in your own mind that this witness is going to turn into a quivering blob of JELLO. He's just going to go like this, and then he's going to basically turn around and say, yes, you're right, Mr. Attorney. You're right. Everything you say is right. I'm so wrong. I'm so sorry. I apologize. That's your hope. That's your expectation. That's your anticipation. Does it happen like that in real life? The reality is, no, it doesn't. Although we would like to believe that it would, based upon courtroom dramas, based upon TV dramas, based upon what we see in the movies, we always anticipate that the good guy who's doing cross-examination gets to the heart of the matter and is hard-hitting and aggressive. And we like to think that that person can go ahead and get this expert to twist their words around, or to get them to concede and to get them to recognize that what they're saying is so wrong and they're on the wrong side of the case. But that doesn't happen like that. So what does happen? What's the reality in these types of cases involving claims against improperly performed medical care, against people who are careless while driving, and even wrongful death cases? Well, here's what typically happens in a case where now we are questioning the opposing expert. The opposing expert, in all likelihood, has very good credentials. Now, how do you address somebody who has very good credentials? Well, if you can't attack them on their credentials, now you look to see if there are collateral things that we can go after them on. Maybe they did some expert witness review for another case, and now they gave testimony that was inconsistent with what they're giving here. Or maybe they did something improper where now they had a problem with their tax returns, and now we can focus on that. Or maybe they had a credibility issue. Maybe they were arrested. There are lots of things that are collateral, not directly relating to their expert review, that we might be able to go after. Another way to use an expert witness is to get that witness to bolster our claim. Now, you might not believe it, but there are some really good trial attorneys in New York who can actually get an expert to go ahead and to acknowledge and to agree that what we are claiming, or at least certain parts of it, are accurate and true. And if we can get the defense's medical expert, for example, to go ahead and bolster parts of our claim, then you know what happens? All of a sudden it gives more credibility to what we are claiming is true. If we can get their expert who comes in here and says, hey, listen, we did nothing wrong, but even if we did something wrong, so did you, Mr. Patient. And even if we did something wrong and so did you, Mr. Patient, whatever we did or didn't do didn't cause or contribute to your injuries. And then they turn around as another defense and say, hey, listen, if we did something wrong and you did something wrong, well, maybe we did cause some of your injuries, but guess what? Your injuries are really not as bad as you claim them to be. So those are the typical defenses that we see in these medical malpractice cases. So now let me go back to the original headline of this article. Will your attorney turn the opposing expert or opposing witness into a quivering blob of JELLO? You know, you may be too young to realize or remember there was a show called Perry Mason. And Perry Mason was always an aggressive, he was always an excellent cross-examiner. But he always got the witness to say things that they didn't want to say, or to admit certain things that, they were hiding. It doesn't happen that way in real life. Once in a blue moon, you can count on one hand, less than one hand, an attorney with a lot of years of experience, 25, 30 years, could probably tell you that there's only one or two, maybe even three instances in their entire career where they've gotten an expert to admit everything that they're saying is true, if ever, and then go ahead and reduce them to tears or to acknowledge, hey, listen, I'm so wrong. I can't believe I gave these opinions and conclusions on behalf of the defense. You're so right. I should have gone to your side, and I should have told the defense that you had a great case. It doesn't happen that way. So these guys are paid to review. They're paid to come in for their time. Now they're coming in to go ahead and explain to the jury why our claim is wrong, why we believe, why everything that we say is absolutely incorrect. So, can you turn them into a quivering blob of jello? No, you can't. However, what you can do is you can get the doctor to acknowledge specific things. So, for example, in a medical malpractice case, one of the key things that I want to do is I want to get from this medical expert who opposes us, I want him to acknowledge what the standard of care was. I want him to recognize what the standard of care was because, I want him to recognize what the standard of care was because the jury needs to know that. It is our obligation as somebody who brings a lawsuit on behalf of an injured patient to recognize what the standard of care is, right? We have to show that the doctor who treated you deviated or violated those basic standards of medical care. So now our medical expert is going to be telling the jury when he gets up to testify, what is the standard of care in this particular instance for these particular complaints and for these problems? Now, when the defense puts on their evidence and puts on their medical expert, and now they get up to testify and I get up to cross-examine, what I want to do is I want to show to the jury that, hey, everybody recognizes what the standard of care is. And it doesn't always happen where the experts agree. In fact, it often does not. They do not agree, right? But my goal is to try and get this expert to agree with certain parts of our standards of care that we're claiming. Doctor, isn't it true that a patient who comes into the office complaining of the following things, the standard of care requires that a doctor do A, B, and C? Yes or no? He's got to agree yes. If he's board certified, then that establishes the baseline for the basic standards of care for anybody in that community as well as across the country. That's the beauty of being board certified. So now, assuming we can agree on the same basic set of facts, and now I can get him to acknowledge what the standard of care was at that particular instance, now we can go ahead and look at exactly what was done in this case to determine whether or not the doctor who treated you did in fact violate the basic standards of medical care. And then we can try and get him to acknowledge that if he did violate the basic standards of care, that was a cause of your injury. Can we do that all the time? No, we can't, but it's something that we have to try. So don't expect that if you are a litigant or even somebody sitting in the back of the courtroom observing a trial going on, that you're going to see during cross-examination the witness throw their hands up and break down in tears and say, you're absolutely right. I can't believe this. This is ridiculous. Why am I testifying on behalf of the defense? It doesn't happen like that. As much as we'd love to see that in our own cases, in my clients' cases, it doesn't happen except on TV, in drama, courtroom dramas on TV, or in the movies. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil cases involving accident matters and medical malpractice and even wrongful death matters here in New York. I recognize and I understand you're watching this video because it comes up in your Facebook feed. And I probably interrupted exactly what you were doing. And you got interested, or you saw me and you saw the headline and you got interested in learning more about this. Or on the other hand, maybe you were searching for this information and now you found it. But either way, if you have questions about something that happened to you here in New York and you don't have the answers to those questions yet, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. As long as it happened here in New York, I can answer them. So you can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day. Bye-bye, everybody.